We will hear first today from Professor Anna Petrig, Chair of International Law and Public Law at the University of Basel, Switzerland. Professor Petrig has worked in private practice, the courts, and the legal division of the International Committee of the Red Cross in Geneva. She has provided expert advice and legal counsel on maritime-related matters to the Swiss government, NGOs, and international organizations, notably on the registration of ships, the use of private security companies at sea, and the protection of underwater cultural heritage. Professor Petrig has sat as judge ad hoc for Switzerland before the International Tribunal for the Law of the Sea, and currently sits on the board of the Swiss Maritime Law Association. She writes widely on the law of the sea, as well as international human rights law, public international law, and criminal law, and is the co-founder and co-editor-in-chief of the Maritime Safety and Security Law Journal. Professor Petrig today is going to give us more of an overview of human rights issues as they arise at sea, the challenges of enforcing human rights standards at sea, and the potential for arbitration to provide victims with a means of redress. Professor Petrig, thank you very much for being with us this afternoon. Over to you.
Thank you very much for this kind introduction and for the invitation to present at this most interesting event. I will be talking about arbitration as a means of effective remedy for human rights abuses at sea. And when it comes to human rights at sea, I guess we have quite a progress as regards substantive human rights law. Back in 2008, France, for instance, still asserted that the Human Rights Convention, the European Convention on Human Rights, would not apply at sea because there is no maritime-specific provision in that convention. However, after having been convicted by the Strasbourg Human Rights Court, they adopted a law in 2011, which is very much human rights based as regards policing the sea. So we have quite a progress as regards substantive human rights law. There is now high acceptance of the principle that human rights apply at sea as they do on land, as David Hammond mentioned at the beginning. However, there's still a bit of an uncertainty what the specific guarantees really mean when applied at sea. When it comes to deprivation of liberty, for instance, what does it mean to be brought promptly before a judge in the maritime setting? However, the real problem is implementation and enforcement of human rights, and Alex has already spoken about this. Enforcement and implementation is very weak. Mary Robinson at some point said about human rights, she spoke of a failure of implementation on a scale that shames us all. And she said that for a land-based context, but when it comes to the sea, it's even worse. Why is there an enforcement gap? Why is it so difficult to guarantee human rights at sea? And I will come back to some things which has been said by Alex. Well, the Earth is quite a watery place. More than 70% of its surface are covered with water. And we have only very limited resources to control the whole area. It's impossible to patrol, control, and monitor the entire sea. So the solution has been that you would subject ships to the control of the flag state, and that the flag state has the primary responsibility to ensure that activities at sea are safe, secure, and in accordance with the law. However, we have a problem with the flag state jurisdiction because we have many flags of convenience. So if you do business at land, you are subject to the jurisdiction of the place where you do business. At sea, it's a completely different world. You can more or less choose your flag, and with this, you choose your law and your court. So you have more or less complete freedom to which standard you want to subject yourself. And it's not surprising, given that there's a lot of pressure, financial pressure, etc., that many opt for so-called flags of convenience. They are quite popular. So flags which have quite low standards in terms of labor, environmental law, etc. I'm taking the example of Liberia. Liberia really ranks at the top when it comes to flag state importance. It has meanwhile overpassed the Marshall Islands, which are number 3, and Liberia is number 2 in terms of flag state. Number 1 is Panama. But when it comes to the rule of law, there are various indexes established by NGOs. Liberia really ranks at the bottom of the league. Like, I looked it up for last year. There's an important rule of law index, and as regards regulatory enforcement, like the willingness and ability to enforce the law, to subject facts occurring within the jurisdiction to the law, it ranked very low. It was state number 102 out of 120 states analyzed. So one of the most important flag states has a very low rule of law index. So you see this gap which is resulting. So the public court system does not really work because we have this problem of flags of convenience, and therefore it's very important to supplement it by some sort of private justice system. Of course, in an ideal world, you would rely on the public system, but we are unfortunately not living in an ideal world when it comes to human rights at sea. And such private justice system could be arbitration. Cronstedt, Aisberts, and Thompsons in a paper defined arbitration as a judicial system without a country. So since the country systems are not working in our case, arbitration provides us with a means to take it away from the domestic systems. So what constellations could be subjected to arbitration? Who are the potential users of the system? David and Alex already emphasized that it's a victim-centered approach. So the most obvious constellation is that individuals, victims, direct victims of human rights abuses would, for instance, make a claim against a business entity. However, it's also conceivable that, similar to some human rights judicial bodies where NGOs or unions can file a complaint on behalf of victims, that you could also have NGOs or unions formulating a claim against the business entity. For instance, because of poor labor conditions. You see here a brochure on so-called sweatships. What is it really like to work on board cruise ships? And you also see the logo of ITF, an important union in the shipping realm. However, it's also conceivable that a business entity is victim of a human rights abuse and it would formulate a claim against another business entity. It has, for instance, become very prevalent that merchant ships rely on private contractors in order to ensure security on board. And it could be that one of these contractors does not behave in a way which is in line with human rights. Another constellation is that an individual would allege that a state has violated its human rights, or even an international organization. Here you see a picture of piracy suspects which have been intercepted and later arrested by Danish forces. You can see the Danish flag on the boat. And they have not been brought before a judge. They spent more than 40 days on board a Danish vessel without seeing a judge, something which would never occur on Danish mainland. So they could, for instance, formulate a claim against Denmark, but often such enforcement mission takes place within a multinational operation. So it's also conceivable that an individual would, for instance, formulate a claim against the European Union or NATO or any other international organization involved in enforcement activities at sea. Yet another constellation would be that the coastal state would formulate a claim against the business entity. This is maybe not directly victim-centered, but if we take the example of Indonesia, Indonesia established a system where they condition the granting of fisheries licenses to fish in their exclusive economic zone upon compliance with certain human rights standards. So if that business entity does not comply with the conditions formulated in order to grant the license, they could subject such a dispute to arbitration. Yet another constellation could be that a flag state addresses a claim vis-à-vis a coastal state. In the law of the sea, you have the principle that the flag state can exercise a quasi-diplomatic protection on behalf of all which are involved in the operation of a ship. So the crew, and it doesn't matter of what nationality the crew members are, it can even exercise diplomatic protection for all others involved in the operation of the ship. So the ship is perceived as a unit and the flag state can act on behalf of them. So it's conceivable that a flag state, a responsible flag state, formulates a claim, for instance, against a coastal state, which arrests a ship and mistreats seafarers, or where deprivation of liberty is not in line with human rights. So you can see that we have many different possible constellations which could be subjected to arbitration, and this triggers the question, what procedure would be appropriate for human rights at sea arbitration cases? And I guess it very much depends on the user. We have seen there are so many different constellations, and in some constellations it's quite obvious that there is an imbalance of power between those formulating a claim and the addressees of the claim. And I guess we would have to have almost different procedure for different constellations and rules which take these difference in terms of balance of power, etc., into account. Well, what approach could we choose for human rights at sea arbitration? I guess an institutionalized system has some benefits. Of course, to pursue a system of ad hoc arbitration without any institutionalization, it's a low-key approach, but it has its downsides. On the other end of the spectrum, we would have an institution, a treaty approach, similar to what we have for ICSID, the investor state arbitration. However, at this juncture, it's difficult to imagine that states would adopt a multilateral treaty. I guess there's a certain treaty fatigue, so I guess that's not a very viable option. But something in between these extremes, an institutionalized system, but based on a soft law approach, I guess there are many benefits to such an approach. Some advantages are mentioned in the white paper. I will not mention them again, but I will maybe add two aspects. One is the visibility. It's much easier to make an institution visible than something which is ad hoc and which changes all the time. And an institution has also what we refer to as an institutional memory. So we have an institution which can collect and publish cases and which can also contribute to building up kind of a corpus of case law relating to the application of human rights at sea specifically. So what are the benefits of arbitration in the field of human rights at sea? Of course, there is the remedy aspect. That's arguably the most important aspect. However, there is also a preventive aspect. If we, for instance, integrate arbitration clauses in contracts, the respective business entity will start managing human rights risk. It has a preventive effect. And I guess these two benefits combined, the remedy and prevention aspect, results in the refinement, development, and stabilization of the human rights at sea regime. If we have a lot of cases, we have a sort of case law, a corpus of case law, so we will better understand what human rights really mean when applied at sea. And also prevention means that there is a lot of discussion and engagement on what must be ensured in order to guarantee human rights on board ships. So this will also contribute to building up a corpus of human rights law specifically for the maritime context. And even if we put the benefits in a broader context, and Alex has already mentioned that notion, the rule of law, I guess arbitration would really strengthen the rule of law at sea. I will end with a quote: "The history of the rule of law is a tale of kings and judges, of revolutions and bills of rights." However, I would reply that it's a tale which plays on dry land. It's a concept which suffers from sea blindness, but I'm quite confident that it also applies in the maritime context. And I guess arbitration would be a step towards a stronger rule of law at sea. Well, on that note, I would like to thank you for your attention, and I look forward to the other presentations and to your questions.
Thank you very much, Professor Petrig, for that extremely insightful overview of human rights issues as they arise at sea and how arbitration can perhaps be used to fill the enforcement gap when it comes to remedying human rights violations.